Good morning. The third case on our docket today is 20-30522, Spears versus Louisiana College. Mr. Pesnell, is that correct?
Yes, ma'am.
Ready for your argument?
Yes, ma'am. Should I proceed?
Yes.
Honorable judges of the court, my name is Whitney Pesnell. I am an attorney with the Pesnell Law Firm in Shreveport, Louisiana, and we represent Carolyn D. Spears, the plaintiff and appellant in this matter. This appeal was taken from a series of summary judgments that were rendered by the trial court in favor of Louisiana College and against Dr. Spears, dismissing Dr. Spears' claims for age discrimination, sex or gender discrimination, disability discrimination, and retaliation under Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, and the Americans with Disabilities Act. The court also dismissed Dr. Spears' claims of defamation and breach of contract under Louisiana state law. We believe that the trial court summary judgments on these matters were and are erroneous as a matter of law, and that they should be reversed and set aside. And this case should be remanded to the trial court for further proceedings on or in connection with those claims. The trial court also denied Dr. Spears' motions for partial summary judgment on her retaliation claims and her breach of contract claims. We believe that those rulings are also erroneous and that those rulings should be reversed and that partial summary judgment should be entered in Dr. Spears' favor with respect to those claims. This matter presents several issues for the court's consideration and review. Those issues include whether or not Dr. Spears was a tenured member of the faculty at Louisiana College when she was terminated, whether Dr. Spears' execution of a retirement option plan in February of 2007 constituted a retirement from Dr. Spears from her position as a tenured member of the faculty at Louisiana College, whether Dr. Spears' termination because LC, Louisiana College, had decided to move in a different direction was for adequate cause, whether Spears was replaced by Jason Tinsley in her position as a professor at Louisiana College, whether Dr. Spears was disabled within the meaning of the ADA as a result of her cancer, whether the letter posted by Dr. Brewer on Facebook in May 18th of 2017 was defamatory per se, and whether Dr. Spears' complaint stated a cause of action for breach of contract. I'll try to provide the court with a brief statement of the case. It's set out in detail in our brief, but I'll try to give the court an overview. Dr. Spears was terminated from her employment as a senior professor at Louisiana College, or LC, by letter dated February 20, 2017, effective July 31st, 2017. At that time, she was employed under a one-year contract to teach 12 hours per semester. That was full-time employment for a professor. The contract says that it is subject to non-renewal, that it is limited to the period of time specified in the contract, and that the contract's issuance offers no expectation of any future employment. However, the contract also expressly incorporates by reference all of the provisions of Louisiana College's faculty handbook, including all of the provisions relating to tenure. Years earlier, in February of 2007, Dr. Spears had executed a retirement plan option, which allowed her to receive the benefits that were then available to employees who retired.
What was the benefit of that? I mean,
I didn't quite understand that.
Judge, I believe
what benefit did she derive from that contract?
they were going to make changes in their retirement plan, and it allowed the existing employees, as I understand it, to preserve their rights to receive the retirement benefits that they were entitled to at that time.
Okay.
Okay. And that's what she did, as I understand it, and I believe it's referred to and cited in the record in our brief. She was not the only professor who was offered the retirement plan option. She was not the only professor who executed it. And she, like the others, did not retire at that time. It was a benefit election.
Let me ask you this. What was the process under the college rules for terminating tenure?
Well, Judge, a tenured employee could only be terminated for adequate cause. I think the phrase was adequate cause, but that was the protection.
Employment, but cutting off tenure rights. What was the process?
Well, Judge, I don't know the answer to that question. Dr. Spears had earned tenure. She began her employment at Louisiana College in 1977. She received tenure in 1984. She was fully tenured from then until 2007. And we believe that it is clear from the record that her position as a tenured professor continued after the execution of the retirement plan option in 2007. In fact, in the record, there's a letter from Dr. Joseph Aguilar, who was the president of Louisiana College at the time, that was written to Dr. Spears that expressly assured her that she was still an employee in good standing of Louisiana College and that she still possessed all of her tenure rights.
All right, I don't mean to tie you up on that. You've got a lot of issues.
Yes, sir. I'll see if I can't move through this pretty quickly. Dr. Spears was diagnosed with cancer in 2012. She underwent treatment and received treatment at MD Anderson between 2012 and 2016. Louisiana College did work with Dr. Spears and accommodate her during that period of time. In 2016, after her cancer treatment had been completed, Dr. Spears applied for sick leave and disability benefits. I believe the application was submitted in August of 2016. She was granted sick leave and disability benefits and received them from August 15, 2016 through May of 2017. Louisiana College.
We're pretty familiar with the background. If you could go through the claims and say what the district judge did wrong on the claim.
Certainly, sir. I'll try to do that. We think the district court, the trial court, erred as a matter of law when it granted these summary judgments because it failed to follow the rules which govern the resolution of summary judgments. It did not consider all of the evidence that was in the record before it. It did not view or consider the evidence in the light most favorable to the non-movement, Dr. Spears. And instead of simply looking at the evidence to determine whether or not issues of fact existed or remained to be determined, it made credibility determinations, weighed or evaluated the evidence, and decided issues of fact. We think those were all improper.
More specific than that. I mean, tell us in each claim what the judge did wrong.
That's what I'm trying to get to, Judge. Let's see. First of all, the standard review on summary judgments is de novo. This court follows the same rules and procedures in evaluating summary judgment as the trial court.
That. I think what Judge Davies is asking is for you to turn quickly to the facts. We know what the summary judgment standard is.
Very well, Judge. The first claim involved here was Dr. Spears' claim of age discrimination. To make out a prima facie case of age discrimination, an employee or a plaintiff must show that they're at least 40 years of age, that they're qualified for the job, that they experienced adverse employment actions, and that they were replaced by someone younger. There's no question that Dr. Spears was over 40, that she was well qualified, or that she experienced adverse employment actions. The trial court said she failed to state a claim because she could not show that she was replaced by someone younger. That is simply not true. Dr. Spears.
The question is whether this was like a riff where you can spread out the workload, or whether this was a replacement. That's the issue.
Well, I don't know if that's quite the issue. The district court asserted that the Louisiana College decided to reorganize and transfer parts of its College of Education to the College of Nursing, including the programs that Dr. Spears oversaw. That is true. But the reorganization did not involve the elimination of any positions, including Dr. Spears' position. It is a red herring. It is a pretext that they have raised to try and avoid the conclusion that Dr. Spears was replaced by a younger worker, a gentleman named Jason Tinsley, who was much younger, much less experienced or qualified, and also male. Dr. Clark.
What evidence is there that he or his wife didn't take over her duties or her classes?
Well, Jason Tinsley did take over her position as a professor and taught all of the classes that she had been teaching before. His wife, Sonia Tinsley, assumed Dr. Clark's administrative positions in the College of Education. Well, it was transferred to the College of Nursing, but she assumed Dr. Spears' administrative duties and responsibilities and filled that job. By the way, Jason and Sonia Tinsley were paid approximately 89 together, the sum of $152,374 for assuming those jobs, which was about $89,900 more than Dr. Clark had been paid for performing those duties or jobs. Now, prior to Dr. Clark's termination, Judge Davis, Dr. Spears' termination, Dr. Spears made arrangements for other members of the faculty to cover for her or fill in her teaching for her on her classes when she could not be available or teach them. She did that herself. The university didn't have to do it, and it didn't cost the university anything. The other professors were happy to work with her and oblige her, and so they were able to do that at no additional cost. After she was terminated, those duties were not spread among other employees. They were not delegated to anybody else by Louisiana College. They were assumed and performed by Jason Tinsley, and on the administrative side, his wife, Sonia Tinsley. Jason Tinsley, as I said, was much younger than Dr. Clark. That's enough to show a prima facie case of age discrimination. Dr. Clark has also asserted claims of gender discrimination, and that's predicated upon the same set of facts. She was replaced in her professorship by Jason Tinsley, who was not only much younger, but was also male. While before she was terminated, when she was unable to perform, when she was on sick leave and disability and receiving disability benefits, she was replaced by a gentleman named Mr. Brunet, who was also male, much younger and much less qualified. But that was a temporary arrangement while she was on sick leave and disability. After she was terminated, they brought in Mr. Tinsley to replace her on a permanent basis. The trial court also dismissed Miss Dr. Spears' claims of disability discrimination. It says that she was not sick or disabled at the time. With all due respect, she may not have been undergoing active treatment for her cancer anymore. She may not have had cancer anymore. It might have been physically possible for her to teach or do some other things, but LC expressly recognized and acknowledged that she was sick and that she was disabled. Dr. Clark at LC helped her put together her application for sick leave and disability benefits, submitted it, and got it approved. And that sick leave and those
disability. Let me ask you one thing about that. What is there in the record to show that she had a disability from her cancer that would substantially limit a major life activity?
Well, we started the court in the case as to the things that we think support that conclusion. But in addition to having a disability, an employee is regarded as disabled under the ADA if the employer regards the employee as being disabled or treats them as being disabled. And LC clearly did that in connection with both sick leave and the long-term disability benefits that she applied for and received.
But there's no evidence in the record of the nature or extent of her disability.
Judge, as I understand it, I'm not sure she was still disabled in when she applied for the sick leave and disability benefits, except for the fact that she had been through the ringer. She was very tired and she needed a break. And
That's in the record.
Sorry, that is in the record. That is in the record. That's in her testimony and in the application of for the sick leave and benefits that was completed by her with Miss Clark's assistance.
Okay.
I want to be clear about this. She was going to continue to get sick leave and disability for the year that she was terminated. And can she get
no,
both?
No. Her contract. She had a 1-year contract to teach from May of 2016 to May or June of 2017. That was renewed. Shortly after that, she applied for the sick leave and disability benefits during that period of time. She did not receive benefits after she was terminated in 2017. Does that answer your?
All right. We can. I don't want to take up more of your time. All right. You save time for rebuttal.
Yes, ma'am. I have all the time in the world, Judge. I'm not worried about my time. I'm worried about doing what the court would like to do.
We'll catch you on rebuttal. Mr. Patin.
Thank you. May it please the court, Darren Patin, here on behalf of the defendant and the appellee, Louisiana College. We respectfully request that this Court of Appeal affirm the trial court's grant of summary judgment in favor of Louisiana College. What stands out today, Your Honors, from not only the appellant's brief, but again, the arguments of counsel, as in the trial court, is the absence of any evidence beyond Dr. Spears' own self-serving arguments and contentions. There is nothing to support her claims, and that's a matter that was readily observed and thoroughly considered and outlined by the trial court in its judgment in favor of Louisiana College. Additionally, and ironically, what stands out in the appellant's testimony is that her own testimony serves to defeat her claims. And there's undisputed evidence based upon her testimony, as well as what Louisiana College has submitted, that there is a lack of evidence to support her claims of discrimination on the basis of age, gender, or disability, and squarely her claims of retaliation, as well as her inappropriately asserted claims of breach of contract, because she simply was not a tenured professor, but an at-will employee whose final adjunct contract was fully satisfied. And then there is the credible and compelling evidence produced by the college, which met its burden to demonstrate that the decision to not renew Dr. Spears' part-time adjunct contract was legitimate and non-discriminatory and did not constitute a breach of the contract or any basis for discrimination. And while this court is tasked with reviewing these matters de novo, we would submit that Judge Dowdy's ruling is sound, consistent with the laws applied to the undisputed facts, and thoroughly supports the affirmation of the trial court's finding and the decision by the Court of Appeal likewise.
Let me ask you something about the particular claim. Now, on the age and sex discrimination claim, the district court said that she didn't make out a prima facie case because she didn't show that she was replaced by someone who was younger or a different gender. And he relied on the fact that this was like a rift where her duties were transferred, spread out across existing employees. And as I understand it, counsel says, and he said in his brief, and I think the plaintiff said in her deposition that Mr. Tinsley took over all of her cases and Ms. Tinsley took over her administrative duties. Now, is that accurate? Is that in the record?
That is not in the record, Your Honor. That's simply Dr. Spears' own testimony and the arguments of counsel. Louisiana College has presented evidence which shows that upon August of 2016, when Dr. Spears reports to Louisiana College that she wants to take long-term leave, those duties are assigned throughout the college's other remaining professors, most of whom are female. Jason Tinsley.
Okay, well, I'm more interested in what contrary summary judgment evidence the plaintiff presented. And counsel said in their brief that Ms. Spears, Dr. Spears, said that these two young people took over her courses and her duties.
And that's the only.
Is that not in the record?
The only thing that's in the record to support that contention, Your Honor, is Dr. Spears' own testimony. It's insufficient.
That's good enough, isn't it? Why isn't that good enough?
Because it is insufficient to overcome what is the legitimate and non-discriminatory evidence that Louisiana College has presented. Louisiana College has presented the testimony of Dr. Clark. Louisiana College has presented documentation showing that those courses have been spread out. In the Grizzle versus Travelers case, as well as the Brown versus Home Depot case, hold that where duties are assigned to others, there is no replacement. There was no person, Jason Tinsley or Sonia Tinsley, who filled Dr. Spears' position. As you analogize it to a reduction in force, the spreading out of the duties, that is what.
There's a fact question. The university says these two people didn't. She says they did. That seems to me it's a fact question.
The fact question can only survive if there is credible and sufficient evidence to support same. The fact question has to be in the context of pretext or the establishment of pretext once Louisiana College meets its burden of showing its legitimate non-discriminatory basis for its decision. There is simply enough in the record to support Louisiana College's burden of persuasion, not proof, and then Dr. Spears' failure to overcome that with her own testimony is what Judge Dowdy noted. With regards to age, it also noted, the trial court, that the decision maker, Dr. Brewer, the president of Louisiana College, is of the same age class as Dr. Spears, which the law provides then the presumption that age discrimination did not support the decision. As it pertains to gender discrimination, again, there are no facts and evidence to support her claims, and she is also not only suggesting that Jason Tinsley replaced her or assumed her duties, but also Sonia Tinsley, which effectively and squarely defeats her contention. That's just based on her argument, irrespective of the fact that she has not presented any evidence to support same. As it pertains to religion discrimination, the appellant is not even presenting an argument at this point. There is no dispute. This court is well aware that Louisiana College is a religious institution, organization, which enjoys the qualified immunity and exemption from religion discrimination under Title VII. As it pertains to the disability discrimination claim, Dr. Spears' own testimony defeats her argument. She conceded at her deposition that she was not disabled when she sought long-term leave. She was capable to and could have taught during the 16-17 academic year, but simply wanted a break. She concedes that she never indicated to anyone at Louisiana College that she was disabled as of August 2016. She concedes that when she requested leave, she knew she was not disabled. And she concedes that she was not diagnosed with stress or anxiety such that she was ordered to take a break by any treating physician or that accommodations along those lines were required. Finally,
yeah, but Dr. Brewer, in the termination, well, I guess it was in his deposition, said that the reason she was terminated is she was not able to teach.
She was non-renewed. She was non-renewed with regards to her contract as opposed to termination.
He said she was not able to teach. I'm quoting the letter.
Dr. Brewer's testimony to that effect is based upon Dr. Spears' presentation to Louisiana College in August 2016 that she was not able to teach that year. That is absolutely correct. She was extended long-term leave for the entire year. She was not able to teach, and in January or February of 2017, for reasons based upon Dr. Spears' own statements and the business decision of the college, that it decided not to renew her position, to not fill that adjunct position, and to assign the duties across Louisiana College's remaining staff. That is absolutely correct. Unrelated to a disability, based upon Dr. Spears' own statements that she was unable to teach that year. The claim of retaliation and defamation really do not need much discussion. I would submit, Your Honors, the tone of the post that was put forth by Louisiana College in response to the criticisms, if not attacks, placed in the public sphere by the appellant's sister were not false, certainly lacked malice, were gracious in tone. There was no tenor of ridicule or contempt. And again, there is no evidence to support the concept that these statements were defamatory, and the subjective feelings of Dr. Spears are not enough to establish same, particularly when you consider the absence of malice.
Let me ask you one question on pretext and on the retaliation claim. That's what the judge decided it on. He said that the plaintiff had not come forward with evidence of pretext, but Dr. Brewer and the defendant gave a number of different reasons for the termination, which always opens a question of what was the real reason. You know, he said when he wrote the letter, he said that they decided to take a different route or something of that nature. And he said they were going in a different direction. And then in his deposition, he said she was terminated because she was not able to teach. And plaintiff also says that the claim that the plaintiff's department was actually merged was really just a pretext, that there was no official action taken that would have authorized doing away with a department. So they set forth all these reasons that would kind of cast doubt on why she was terminated. What do you say to that?
Again, simple argument, contentions without any evidence. Louisiana College did decide in the early part of 2016 to transfer some of its physical education courses from its education department to its College of Nursing, a best practice decision in line with the practices of other colleges across the country. It is, I would submit, absurd to believe that the university would go through these sort of decisions, reorganizations, simply for purpose of setting up an opportunity to not renew Dr. Spears in her contract, particularly when these decisions were made before the 2016-2017 contract was offered to Dr. Spears. As it pertains to Dr. Brewer's testimony with regards to his considerations for the non-renewal, they are all consistent. Again, Dr. Spears did not teach the 2016-17 school year, approached Louisiana College seeking long-term leave, indicated to Louisiana College that she was unable to teach. A business decision was made in that regard, also in line with and consistent with the decision of the college to transfer its physical education department to the College of Nursing. All consistent, but most important, again, and with respect to Judge Dowdy's findings, which I would submit this court would also find as well, is the absence of any evidence to support these contentions. Dr. Spears can contend that the college decided to eliminate the School of Nursing if she wanted to, but without any evidence, without any support for saying there is no basis to establish pretext where Louisiana College has met its burden by presenting a legitimate non-discriminatory reason.
Let me ask you this: when her classes were taken over by Mr. Tinsley, was that in addition to duties he already had, or did he just simply replace her?
He did not replace Dr. Spears. Jason Tinsley was placed in another position at Louisiana College. It is a misrepresentation to believe or to suggest that Jason Tinsley was hired to replace Dr. Spears. He simply was not.
Did he teach her classes or not?
He did not teach her classes. Her classes were spread across the departments.
What is the evidence? And there's actually evidence in the record that says that.
There's evidence in the record that says that, Your Honor. There's testimony from Dr. Clark. I believe we submitted an affidavit of Dr. Clark as well, but certainly her deposition testimony supports that. I believe that we have also submitted in the record of the trial court the course schedules for Dr. Spears and how those schedules were also transposed across the remaining staff in the 2017 and 2018 school years.
Okay, now about the disability, I don't understand. You say she's not able to teach, and if she was terminated for that reason, then she says, no, I am able to teach. Why didn't the university respond and say, okay, if you're able to teach, we'll let you?
She was not disabled. She was not considered as disabled. She admits that she was not disabled.
Then why did he write the letter that said she's not able to teach?
There was no letter written by Dr. Brewer which suggested that Dr. Spears was unable to teach. It was his testimony that the decision to not renew the contract was based upon Dr. Spears's presentation to Louisiana College in August 2016, stating that she was unable to teach that year and that she was seeking long-term leave. She admits that she was not disabled. There was no disability that was precluding her from teaching. It was her decision to not teach that year, and that was Dr. Brewer's testimony. She stated she was unable to teach. That was considered with regards to the non-renewal in February 2017.
You do see the tension there. You keep saying she was not considered disabled, yet she was saying she's unable to teach.
She admits that she was not disabled, Your Honor. She admits that she simply wanted to take a break, and it was unrelated to her cancer treatment. The break that she was referring to was what she viewed as a culture change at the college with regards to the physical education department being taken from education to nursing. Through her 20 plus years at the college, the physical education department was within the Department of Education. And that was what she felt was a stress and an anxiety that she needed a break from. She elected to not teach the 2016-2017 school year for reasons that were unrelated to any claimed disability, which she admits that she was not disabled. There was simply no disability that she would qualify as an individual with disability, and the college never regarded her as being disabled. There is a distinction here with regards to her stating, I am not able to teach this year and getting long-term leave and being disabled from teaching. Finally, I would address the issue with regards to what she claims to be a breach of contract. That claim was not asserted in the complaint. Judge Dowdy noted that. The paragraph in the complaint, which is most pertinent, is paragraph 3, which outlines the causes of action. Within paragraph 3 is no statement of a breach of contract. It is clear that the Contreras case out of the Fifth Circuit, you cannot raise a cause of action in response to a motion for summary judgment. It has to be contained within the pleadings, and it was not. Irrespective, Judge Dowdy addressed the issue and determined that on the face of the adjunct contracts that were issued to Dr. Spears from 2007, when she initially retired from full-time tenured position to take advantage of the retirement benefits, to 2016, she was an adjunct professor at Louisiana College. The contract specifically states that it is a one-year contract with no promises of future contracts. That is in clear and stark contrast to the tenure contract that she executed in 2006, 2007, which makes clear that she is tenured and that tenure and the promise of continued employment exists. She decided in 2007 to take advantage of a retirement benefit.
Let me go back to the disability issue, because you keep saying, well, she decided she didn't want to teach for the 2016-2017 year, but we're talking about the 2017-2018 year. That was the year for which her contract was not renewed. Now, what, and the college says she was not able to teach during that year. And apparently she's saying, I did want to teach for that year.
The issue is
2017-18.
I understand, Your Honor, the 2017-18. Dr. Spears was not disabled. She is not taught since 2016. In 2017 and 2018, she was not disabled from teaching, but when the decision was made to not renew, she was not working at the college. She was on long-term disability leave. She was not guaranteed continued employment.
Well,
And
either, okay, that's the point. If she's on disability leave, then
I'm
why
so-
was
she's,
the,
I'm
you just
sorry, Your
said
Honor.
she was. You
Not
just said,
disability leave. That was a mistake. She was on long-term leave. She was not on disability leave. She was not disabled. She was not teaching the 2016-17 year. She was a one-year adjunct professor, and the university, the college made a decision not to renew her contract, irrespective of the fact that she was not disabled and could teach.
well, my only point is, in his deposition, a representative of the college did say, we terminated or did not renew because she could not teach. Did he say that or not?
That was a statement that Dr. Brewer made at his deposition, but it was not that she could not teach because of a disability. She elected to simply not teach. It was
But not for
non-disability
the
related.
2017, 2018 year, what evidence is there she elected not to teach for that year?
Her contract was not renewed.
And we're asking, and the representative of the university was asked, why was her contract not renewed? And he said, because she cannot teach. Now, what evidence is there that she could not teach for the 2017, 2018 year?
There is no evidence that she could not teach for the 2017-2018 year, Your Honor, but she was not guaranteed employment
That's
for the
beside the point. I'm
2017,
just saying what
2018.
I'm saying. The university gave that as a reason, and now you're saying that wasn't the real reason.
I'm not saying that.
Well,
I'm saying that there's a difference, Your Honor, between not teaching, not being able to teach for the 2016-2017 school year, and not being able to teach because of a disability.
I'm talking about the 2017, 2018 school year and why she was not renewed. Well, we're just, never mind. The record is what it is. I don't think you're helping it.
Yes, let me ask him one other question, Chief, if you don't mind. On the breach of contract claim, I'm looking at the contract that the year contract she signed, and it said that nowhere in there does it say that her tenure is canceled. It says this contract is limited to the time period specified in the contract, and the issuance of this contract offers no expectation of any future contracts. But she had an existing status of tenure, and that seems to be recognized here by saying that all the terms set forth in the faculty handbook is incorporated into this contract, and that handbook says that if you have tenure, you do have expectation of future employment. So is there any other evidence of cancellation of her tenure?
Correct, Your Honor. The 2007 documents, the retirement plan option document that she executed, as well as the adjunct contract which she executed in 2007. The retirement option documents that she executed in 2007 make clear that she is retiring from a full-time position and then will assume the position of a senior adjunct professor at Louisiana College, which is clearly a non-tenured part-time position. That is in the record. So you will want to take a look at the 2007 retirement option documents. You want to take a look at the 2006 tenured contract, and you will want to take a look at the 2007 adjunct contract. And that will make clear that in 2007, she retired as a full-time professor, assumed the position of a part-time senior adjunct professor, which is a part-time non-tenured position at Louisiana College, and continued in that position for 10 years until 2017.
Yeah, then the former president wrote her and told her that go ahead and sign that one-year contract. It's not going to affect your tenure.
The president of Louisiana College does not have the ability to extend tenure. That is a matter that is determined by the board. And the board has researched its records. The affidavit of Mr. Hargis, which is in the record as well, indicates that there is no action ever taken by the Louisiana College Board which shows that Dr. Spears was extended tenure in 2007 or after while she was serving as a senior adjunct non-tenured professor in a part-time position at the college.
Now, that other document you're talking about, the '07 document, is that in the record?
Yes, Your Honor.
What about the reorganization? Is that reorganization by the board? Is that in the record?
The reorganization of the physical education department from education to the College of Nursing division, that's what you're referring to, Your Honor?
Yeah.
That is, the documentation is in the record, particularly with regards to the testimony of Dr. Cheryl Clark as well as Dr. Brewer. We also attached the testimony of the former Dean of Nursing at Louisiana College, who testified to those conversations taking place prior to her departure.
You don't have a board resolution though, do you?
A board resolution with regards to the reorganization, that was no, that was a matter that was handled at the executive level, at Louisiana College, the administrative level. It did not require a board resolution.
But you just had some people who testified that that's what happened.
Yes, Your Honor.
You don't have any official action by the board, evidence.
Action by the board? No, Your Honor. But again, that was a matter that was handled and the reorganization took place below the board level.
Any further questions? Thank you.
Thank you very much.
Mr. Pesnell, I'm sorry, I'm not pronouncing your name correctly.
Pesnell, that's fine, Judge. There are a lot of things that are said there. First of all, Judge Davis, you're absolutely right about tenure. She earned tenure through her full-time employment for 30 years. She received it in '84. She did not retire in 2007 or relinquish her tenure as President Aguilar's letter confirmed. Now, it is true that in 2007, she started working under a series of one-year contracts. But those contracts did not define the totality of her relationship with Louisiana College. And they are not inconsistent with the fact, as you've recognized, that she had tenure and was entitled, she had an expectation of future employment, whether it was through one-year contracts or not. And that tenure persisted. You're absolutely right about that.
Is she receiving retirement benefits? Did she start receiving retirement benefits after she was no longer renewed?
I'm sorry, Judge, are you talking about in 2007 when she executed the retirement plan option? Are you talking about in 2017 when she was terminated?
2017 when she was not renewed.
I don't believe that she's received retirement benefits. I don't know that for sure. Not to my knowledge. Now, in his arguments, Mr. Patin said that Louisiana College had articulated a legitimate non-discriminatory reason for discrimination in connection with her age and gender discrimination claims, and that she was unable to rebut that. I don't know what that has to do with anything. The trial court did not rule that LC had articulated a legitimate non-discriminatory reason with respect to those claims, or that she had to make a showing that it was pretextual. The trial court dismissed those claims because it said she didn't establish a prima facie case. And it said she didn't establish a prima facie case because she couldn't show that she was replaced by Jason Tinsley. But that is, in fact, exactly what happened, Judge. There is competent evidence in the record to show that. The citations to the relevant portions of the record are contained in our brief. And so that argument really doesn't have any merit. I would like to address, if I can, her state law claims. First, the defamation claim. In his letter, Dr. Brewer, the letter that was published on Facebook, Dr. Brewer indicated that she had retired in 2007. That was not true. That was false. He indicated that she had been working as an adjunct professor at Louisiana College. That is not true. If you read those one-year contracts, you will see it describes her as a senior professor, and that it provides that she is to teach a full 12 hours per semester. That's full-time employment. An adjunct is someone who works part-time. It says that she was non-tenured. That's not true. Her tenure was still in force and effect. Dr. Aguilar's letter establishes that beyond cavil. That letter indicated that she was unable to teach. And that letter also indicated that they had been paying her for 2 years, even though she hadn't taught a single student during that period of time. A statement which is absolutely false. I think the record shows that she taught 411 students in different classes over a significant portion of that period of time. Now, there were times when she couldn't teach, but it was because of her sickness and her disability. Now, when she applied for the sick leave and the disability benefit, she may not have actually had cancer, and she may not have actually needed further chemotherapy or radiation or surgery in connection with her cancer. But she was exhausted and tired from several years of treatment, and she needed a break. That is true. She applied for the sick leave and the disability benefits, and she did it with and through Ms. Clark, who approved all of that. They've supported her application for disability benefits. She was paid disability benefits for that period of time. For them to come in and say that she wasn't disabled and she is entitled now is absolutely absurd.
Does the record contain evidence of when she actually taught and when she didn't?
I believe it contains evidence, Judge, that shows that she taught the 411 students during a significant portion of that time between 2016 and 2017, or maybe in the previous year, 2015 to 2016.
Do you have any evidence other than her statement?
I am not as familiar with the record as my father, Judge. I don't know that, but I know that the record is, the arguments in our brief are amply supported by citations to the portions of the record which support it. I can't answer that definitively for you.
Okay.
Anyway, most of these statements.
Counsel, your time has expired. I think we have your arguments. And thank you.
Very well, Judge.
Thank you very much.
That will conclude the arguments for today. The court is adjourned until tomorrow. Thank you.
Thank you.
Thank you.